Another Baragoi Farmers Cooperative Society Limited and others moved to court to challenge the decision by the National Land Commission. The court made the determination and based one of the bases that the Anata Baragoi and other parties who own the titles to that land, that the National Land Commission made a determination in favor of the historical injustice for the Tenda people. The court, one of the bases that the Angata farmers went to court was on the basis that this determination was made when God was in the class. As the owners of the title, we already have the title to that land. And the court made a determination saying, in fact, in 343 says, if such proceeding did happen, which the court highly doubts, the petitioners herein, all the persons who have been affected, who are lawful registered landowners of another Moyoi adjudication section and Moyoi adjudication section were never notified of any claim or complaint of historical land injustice and were never given an opportunity to be heard before the first respondent and made the recommendation to cancel and revoke their ownership documents. It further goes in conclusion to say, Honorable Chair, that in 357B, a declaration be and is hereby made quashing the first respondent determination under the claim of historical land injustice number 19 of 27, pronounced on 7 February 2019 and published in the Gazette number 1550 dated 1st March 2019, recommending first and second interested parties to cancel and revoke the documents of America. That is the first determination. The second one, which the Honorable Chair is reading in half, is a permanent injunction. B is hereby issued prohibiting first to third respondent interested parties from implementing the quashed determination by the first respondent in the proceeding referred as NLC/HLI 19/2019 in regards to the petitioner's ownership documents and generally all titles issued in Anata Baragoi Education Section and Moyoi Education Section. This is in regards to the HLI decision. All titles issued in regards to this HLI, not for the entire education section, Honorable Chair, just for the interpretation of this decision, Honorable Chair. So, Honorable Chair, and it is important to note that among the people who are taken to court by this the case, Honorable Chair, is actually Munyonge and Ahaki as independent, as an interested party. So this decision made by the court, the Munyonge and Ahaki who petitioned Parliament cannot run away from it, Honorable Chair, because they were in court as an interested party when this decision was made. They have not challenged this decision in the Court of Appeal, Honorable Chair, but they have come to Parliament instead of challenging this decision at the Court of Appeal, Honorable Chair. Number 339. If you look, there was actually a question on whether there was a historical land justice case filed before NLC. And the court ruled in number 329 that in essence this court therefore makes a finding that there was no claim of historical land justice that was ever admitted by the first respondent, facilitated a lawful hearing and determination as pronounced on it. So in the court, because there is a procedure of finding a historical land justice, so maybe Chair, unless the National Land Commission started again by filing a fresh historical justice, otherwise it cannot move on its own condition based on this one, because the court actually ruled that there is a procedure that is not followed. Maybe I just wanted to interject on that. So,
allow me also to interject. I've been getting his submission from the one group. I think it's a partisan case because even these people are involved in this dispute.
Education section time, because those are two different things. Because some of the titles might have moved to third parties for purposes. You want the list now, you want the searches as of now or as of adjudication?
I think both would be.
You want the history?
Yes.
And then timelines.
Actually, without being that or seem to be biased. Honorable Chair, I've had a meeting with the Marwa and Marwa Kitayama on the same matter, on this matter, previously. And when they came to my office, they were seeking how do we help the group of people because they're also parents and they're suffering. Honorable Chair and the way they were coming was how do we get land purchased through the settlement to settle these Kenyans. Because they are also residents there. The fact is that, Chair, there is no unallocated land in the entire Moyoi. It's all allocated and titled, occupied. There's a portion of the land that belongs to Angata farmers, where we had incidents of even police shooting people the other day. And the incident happened because there were people now from the Sikis community who had gone to the land and they were farming the land. Some of them are also from Kuria, farming the land. But we understood that that land belongs to the Angata farmers. Of course, there were some challenges in court. In fact, there was an Angata, it's called Angata Association, that went to court to take the Angata farmers on regards to that title, which is 6,000 acres, not the entire Moyoi. And the court ruled in favor of Angata farmers, which was the title that was created long time ago by the ministry and allocated and given to Angata farmers. Fast forward, Honorable Chair, last year there was a mediation entered by these two parties in regards to that land. And there was an agreement entered by the two parties in regards to that land to the effect that a consent was filed in court that a portion of 1,500 acres be given to the Christians. When that consent was going to be implemented, then there was a dispute on where the 1,500 starts, and that's where the fights happened. We again sat, Honorable Chair, with the two communities, brokered a mediation. I went to the ground together with the Honorable Sunguli and other leaders to now the farm itself to meet the two parties and mediated to the effect that they will surrender the 1,500 acres, government will buy another 1,500 acres to solve the two communities that were fighting there. That will solve the issue of the dispute that was there between the Kipsigis and on this matter. Then now, Mheshimiwa Robi came and said, there is another community you left out. The government should have also sat and see how we can solve this matter, Honorable Chair. And that was a discussion that we are beginning to have. Now, this is now an historical issue that has been determined by National Land Commission, which the National Land Commission has confirmed that the State Department did not participate because they did not present their documentation to it. Nonetheless, a decision was made by the National Land Commission, which now the Angata farmers and other parties who had been given their titles went to court to challenge and successfully challenged this decision of the National Land Commission. The options that we have is to appeal that decision, which now will also give us, even if that decision was to be ruled in favor of the tender community, then we have a whole population that is sitting there again that needs to be sorted because they are also Kenyans. So we have to look at it in how do we solve this problem without causing also another problem. And that's why, as a PS for lands, I have to give the factual position so that the committee may be able to make an informed decision. Which I would propose that even as this petition is listened to, Honorable Chair, it is important to note that there is no unallocated land in Moyoi adjudication section. The claim for 20,000 by the tenant community for the 20,000 acres is based on an agreement that they bought this land from the Syria community in 1949 or thereabout. And their interest ought to have been noted when the adjudication process was ongoing. I don't know why it was never considered or it was ignored at that particular time, because we wouldn't be here. So that has prompted now the tender community to petition Parliament, because after the initial decision was made, then again we have to petition. So it's either we start it afresh as a new filing of an historical injustice, which is processed now by the National Land Commission, but still again, noting that there are also titles that are being processed there, which will also be part of the historical injustice case. So I think we should be, to me, we should be trying to see how do we find a solution to settle all these Kenyans. Because the danger of the direction that we might take is we might get into a gridlock, where whatever decision that is made, if you make a decision in favor of the tender, then we have another problem. We make a decision that we uphold the court decision, then what happens to these other cases? So I think we need to find how we can deal with that matter on the chair, with those facts on the table.
Yeah.